Hello everybody, if you like this video, please consider donating to us on Patreon. We want to keep on making education free and available to everybody, no matter what. So this is a perfect way to do that. There are different tiers and different ways you can donate. If you did enjoy this lesson and you've got some money to spare, please consider donating on Patreon. So what we have here is a possible exam question for politics, and it's simply asking us: civil rights and civil liberties have been eroded in recent years, discuss. And this would be a really nice question to get in an exam, if I'm honest. And what we're going to do is going to go through each little bit in detail, look at some evidence that you may not have heard of before, some evidence that's not in the textbooks, and start to formulate an answer. So the first thing that we need to talk about is the introduction. So let me just zoom in a little bit more. There we go. So we've got to look at the introduction. And what's important in the introduction is a couple of things. So for one, it might be useful to simply define these terms, because it's asking you that civil rights and civil liberties have been eroded in recent years. It might be useful to explain what these things are in very brief terms. And generally we can use, you don't have to use a specific precise definition, just one that really fits these two points. So arguably you could just say that civil rights and civil liberties are rights and liberties which are afforded to individuals. Rights and liberties that are afforded to individuals. And then also the thing in your introduction, another thing you need to do in your introduction is explain what your argument is going to be. Okay, are you going to argue for the statement in question, that they have been eroded in recent years, or are you going to claim that they haven't been eroded in recent years? So make an initial claim. Okay, make an initial claim. And this is really important because it sets out in your introduction straight away what this essay is going to be about. So you define what rights and liberties are, and then you say, you know, the central thesis of this essay is to claim that civil rights and civil liberties have been eroded. This will be achieved by, and then you maybe list the what your paragraphs are going to be about. I'm going to do a separate lesson on making the perfect introduction for A-level politics, for effectively any essay-based A-level. But in this lesson, we're just going to look at this specific question. So the first thing we're going to do when we plan this question is just to really split it up into two, because we're being asked two sides. We've got to really argue two sides of the argument, and we've got to get a balanced argument between the two. So the first side of the argument is yes, they have been eroded. So yes, civil liberties have been eroded. Okay, put a comma there for, you know, grammatical accuracy. This is the first point that we're going to make. Now, what can we list as evidence for civil liberties being eroded in this first section? Now, I think the first thing that most people would argue is the introduction of terrorism legislation. So, terrorism legislation since the 2000s. Okay, terrorism legislation since 2000. Okay. This is a very important point. Ever since terrorist attacks like 9/11 and the 7/7 attacks in the UK, we've seen a number of acts of parliament that seemingly take away and erode and infringe upon individuals' civil liberties. Now, the first and the main one, arguably you could talk about, is the Terrorism Act. The Terrorism Act of 2000. So the Terrorism Act of 2000, which effectively defined a terrorist, prescribed organisations, and outlined powers of seizure and stop and search. Okay, so we've got from the Terrorism Act, you have things like stop and search powers. We have things like the disclosure of information. These are just kind of the things that are directly involved when we're looking at the Terrorism Act. Another act of Parliament that we could talk about is the Anti-Terrorism Crime and Security Act. Anti-terrorism, terrorism, if I can spell, Crime and Security Act. Crime and Security Act. And this was in 2001. And under the Anti-Terrorism Crime and Security Act, we get things like an increase in stop and search powers. So an increase in stop and search powers. And this is, there might be cases of stop and search powers that allow an officer to stop and search even a suspected terrorist without any real justification to do so. Okay, and we're going to talk about the Anti-Terrorism Crime and Security Act in a little bit later on when we look at a couple of Supreme Court cases. If you want to look at more recent acts of Parliament that have eroded on civil liberties with regard to terrorism, we also have the Counterterrorism Security Act of 2015. So Counterterrorism and Security Act of 2015. Now this Act of Parliament effectively gave the state powers to seize passports of suspected terrorists. So we've got the seizure of passports for suspected terrorists. So what's important is the word suspected. I'm just going to put that in big. Suspected terrorists. So the rule of law principle of innocent until proven guilty effectively has been thrown out the window with most of this terrorism legislation that was enacted after 9/11. And we also get things like greater surveillance powers with this act. So we get greater surveillance powers. Okay, greater surveillance powers. So all of these are acts of primary statute law that can be used to make the claim that civil liberties and civil rights have been eroded in recent years to support the statement that's in the question. Okay. Now we also have another point that can be made regarding the ECHR, which is the European Convention on Human Rights. So, and this is the principle of derogation. So derogation. Okay, and this is part of Article 15 of the ECHR. Now, what this effectively did is that you can do something called derogating, okay, when certain conditions are met. And we'll look again in a piece of case law in a minute that counters this claim. That the idea is that the state can use derogation as a justification for some erosion of human rights and civil liberties. And the point in the ECHR is that derogation can be confirmed, can be done in times of war. So in times of war, or other public emergency. Okay. And this is specifically to when it comes to threatening the life of the nation. So this is the quote from the ECHR. Threatening the life of the nation. That's what is stated in the ECHR. So what's important here is that the ECHR is providing a provision where the state can effectively justify and explain away and argue for the effectively the derogation of human rights. And this is something that has been argued in the courts, and something that we will look at when we look at the opposite side, of whether or not this actually is an effective erosion. One other point that should be made, that could be made if you're feeling brave, is to talk about COVID legislation. So COVID-19 legislation. So this comes in regards to things like the Coronavirus Act, the Coronavirus Act of 2020. Now, a number of arguments have been made when it comes to enacting primary legislation in times of crisis, which is what this year has effectively been. And what the Coronavirus Act allows is it justifies, shall we say, emergency powers for government. Emergency powers given to the government. Okay. Now, what's interesting here is that you could argue that this is an erosion of civil rights and civil liberties, because things like forced lockdown, charges and fines for breaking rules relating to coronavirus can be seen as a human rights issue. Now, whether or not this is justified, that's not part of the question. The question isn't is the erosion of civil rights and civil liberties justified. Now, many people argue that the Coronavirus Act and the emergency powers that came with the Coronavirus Act is justified in order to stop the spread of a virus and the pandemic. However, the question isn't whether or not it's justified, it's whether or not these emergency powers did at all erode civil rights and civil liberties. Okay. Now, as a little bit of a side note, that if you want to do your own research on when it comes to the relationship between the emergency powers and Coronavirus Act and the human rights and civil liberties of individuals, look at comments made by the former Supreme Court Justice, Lord Sumption. He makes that's an N, not an M. He makes a number of arguments against the sort of human from the legal and the civil liberties side of this argument. He makes a number of comments there. So if you want to do a little bit of extra reading and extra research on that, there's some interesting opinions that he has. Now, when it comes to looking at whether or not civil liberties have or haven't been eroded, we have to look at the other side of the argument. So we have to say, no, they haven't. Okay? And this is quite a nice one to do, because what you essentially could structure your essay as is you could list all of these reasons why we see civil liberties being eroded, but then counter all of these points by talking about various changes and precedents that are set in case law, so recent cases. So let's have a look at a couple of cases. I'm going to start by looking at the issue of the derogation and Article 15 of the ECHR. I'm going to look at the case A and Ors, and Secretary of State for the Home Department. Okay, now this is a case from 2005, and just like with any kind of English case law, instead of saying v, we say and. So you know, a and ors and Secretary of State. In America it's v, so you know, don't get that mixed up. Now the facts of this case are very interesting. Effectively, the claimant, which is this side, okay, they were detained under Section 22 and 23, under Section 22 and 23 of the Anti-Terrorism Crime and Security Act, which is the one that we've looked at here. This one here, Anti-Terrorism Crime and Security Act. So we're going to just abbreviate this to the Anti-Terrorism Crime Security Act 2001. Okay. And the justification for this was under a derogation order. A derogation order. Okay. So the argument that the Secretary of State for the Home Department made was that they were justified in arresting and detaining the claimants under this act of legislation because Article 15 of the ECHR allows for derogation in times of public emergency threatening the life of the nation. So, by extension, their reasoning suggests that they were in a time of state emergency and a threat to the life of the nation, and that is why this derogation order was valid. However, the claimants argued that the derogation order was flawed. So derogation order was flawed, and this was because they argued this on 2 points. Okay, they made 2 points for why it was flawed. Point 1 was no public emergency. There was no public emergency. Therefore, derogation order shouldn't have been allowed. And 2, that the derogation order, even if there was a public emergency, it was disproportionate and discriminatory. So disproportionate, okay, and discriminatory. So these are effectively the facts of the case and the arguments made by both sides. So I'm just run through it again. The claimants, A and Ors, okay, were detained under subsection 22 and 23 of the Anti-Terrorism Crime and Security Act 2001. The Secretary of State for the Home Department argued that this detainment was valid and justified because of the derogation order, which is a part of Article 15 of the ECHR. Okay? And by that reasoning, they are suggesting that the country was in a state of public emergency and there was a threat to the life of the nation, because otherwise the derogation order would have been invalid. So it all stems upon whether or not the derogation order was valid or not. The claimants argued it wasn't for 2 reasons. 1, that it was not a public emergency, and 2, even if it was a public emergency, it was a disproportionate and discriminatory. Okay? Now the courts, the House of Lords specifically, the House of Lords, which if you remember from the section on the Constitution, originally sat the highest court in the land, the Law Lords, until they moved to the Supreme Court in 2009. The House of Lords ruled 8-1 that the derogation order was flawed. So that the derogation order was flawed. Okay? And they agreed specifically with point number 2, that it was disproportionate and discriminatory. And because there was no justification through this derogation order, it was therefore incompatible, okay, with Articles 5 and 14 of the ECHR. And therefore a breach of civil liberties was ruled, and therefore the House of Lords ruled in favour of the claimants, okay, and effectively protecting civil liberties in this case. So I'm just going to go over it again one more time because it can be quite complicated. I'm just going to briefly go over the facts of the case because I've already gone over this twice already. So we have a detainment under subsection 22 and 23 of the Counterterrorism Security Act. The reasoning why this was justified is because of this derogation order, a derogation order which is something which is allowed under Article 15 of the ECHR in times of public emergency and the threatening of the life of the nation. Okay. The claimant said that the derogation order was flawed for two reasons. One, because there was not a public emergency, and two, the derogation order itself was disproportionate and discriminatory. The House of Lords agreed with the second point, mainly the second point, and that the derogation order was flawed, and because there was no derogation order in place, it was the detainment was incompatible with Article 5 and 14 of the ECHR. So that is a very, very good case that you could talk about, especially if you're going to make reference to the fact that you can have erosion of civil liberties under Article 15. You could talk about this as a way of, sort of protecting civil liberties against this order. We could also just make more general points against the claim that's made in the question, which is just the Human Rights Act. The Human Rights Act was passed in 1998. Okay, this brings ECHR into UK courts effectively. So before 1998, if you wanted to make a claim to the European Convention, the European Court of Human Rights, the ECTHR, what you'd have to do is go to Strasbourg, where it is, and make that claim there, which is costly and expensive. The Human Rights Act brought these provisions into UK legislation, so therefore it's easier to protect your civil liberties and human rights in these cases and circumstances. Okay. There are also cases of human rights, protection of human rights in the States for terrorism. Okay, so we're going to look at one more case before we finish, and this is the Secretary of State for the Home Department and JJ and Oars, 2007. Okay, so I'm just going to Secretary of State, SOS, okay, for the Home Department. And we're going to and JJ and Oars. Okay. Now, actually, no, we're not going to look at that case. That's not a very good case. Let me just try and find the right case here. Sorry about that. Hang on. Let me just scribble that out. So, okay. So here we go. We've got another case. That was a piece of case law that it would be relevant. You could talk about it, but it is quite complicated and it involves a lot of prerequisites to me having to explain a number of points and key things that happened before to try and get the background of the case. So it's easier to look at this one instead, which is Gillen and Quinnton and the United Kingdom. So Gillen and Quinnton and UK. This was in 2010. Okay, and effectively the facts of this case are, oopsie daisy, let me just do this properly. Get a nice straight line. There we go. So the facts of this case are very simple. The applicants were stopped and searched by the police. Okay. And so applicants were stopped and searched by the police. So this is the point that this is, you know, what caused the issues in the first place. The police argued that they were allowed to you know, give the power to stop and search without reasonable suspicion, okay, under Section 44 of the Terrorism Act 2000. So Section 44 of the Terrorism Act from the year 2000 gave the right to stop and search, okay, which we've already talked about already. Okay, so this case we could say is an argument against the point up here, that yes, there's been an erosion of civil liberties and civil rights due to the introduction of all these pieces of terrorism legislation. However, when it comes to the enforcement of this legislation, the ECHR still protects individuals, which is what happens here. Okay, so these were the arguments to the court. Okay, it was found that Section 44 specifically of the Terrorism Act was a violation of Article 8 of the ECHR. Okie dokie. So the Court of Human Rights, so the ECTHR, ECTHR held that the measures were not in accordance with the law. Okay, so they were not, so held not in accordance with the law. Okay, with the law, and they said that this was because there was a lack of proper safeguards. So there's a lack of safeguards. So this is effectively an open and shut case, a really easy one to understand. The applicants were stopped and searched by the police, and the police's justification to stop and search is that they said we have the power to do this without, you know, any reasonable suspicion. We don't really, it doesn't matter because of Section 44 of the Terrorism Act. They took their case all the way to the European Court of Human Rights. Okay, and this is why we have the claimants versus the United Kingdom rather than the claimants versus the Secretary of State. So this was an ECTHR case, okay, and they held that this was in violation of Article 8, and they said that it was not in accordance with the law. So in general, what we've talked about a number of things, okay, that we could make reference to when we look at this question. Has there been an erosion in recent years? You can make a number of arguments. You could talk about, yes, there has been an erosion because of terrorism legislation since the year 2000, and most recently, one of the most recent is the Counterterrorism Security Act, okay, which allowed for the seizure of passports for suspected terrorists, which is very interesting, okay, and greater surveillance powers, again, for suspected terrorists. You could talk about the fact that some of the erosions and attacks on civil liberties can be argued and justified under the derogation clause of Article 15 of the ECHR, which is very interesting, okay? And when it comes to there being in times of public emergency or war, the threat to a nation, there could be an extension of and effectively an erosion of civil liberties, even under the ECHR. Some people have argued also that we've got has been an erosion this year specifically with the Coronavirus Act and the emergency powers that were given to the state due to the coronavirus pandemic. And like I said, if you want to read up a little bit more, the former Justice Lord Sumption is very good when it makes a very number of interesting arguments for this point. And then we can counter these points quite easily, and we can counter these points by using cases. So the first case talks about the problem with derogation. So the Secretary of State there was a detainment under a law, okay, the Counterterrorism Security Act, and they claimed that this was in accordance with the derogation order. The claimants said that the derogation order was flawed, and the House of Lords agreed with them. And then we can also talk about a very easy case to understand. Applicants were stopped by the police. The police said that this was allowed under Section 44 of the Terrorism Act. The ECHR disagreed and said that it was actually in violation of Article 3 of ECHR because there was a lack of safeguards and it was not in accordance with the law. So this is we've got quite a little bit of interesting other pieces of evidence that you probably wouldn't have seen in the conventional textbooks. There are obviously other ways you can answer this question, and if you want me to add any more, I'll put it down below. Other pieces of evidence that you could talk about, things like the Freedom of Information Act. But for now, this is a good way of answering a question of this nature.